Okay, well, welcome to you all to this webinar by Landmark Chambers, Pinsent Masons and BNP Paribas. You can see the title, Levelling Up and Regeneration Bill, focusing on the planning and key practical implications of the proposed arrangements. We're delighted to have so many of you joining us this morning. I hope you find the presentations and the discussion that will follow each one and at the end useful to you. My name, for those of you who don't know me, is Rupert Warren QC. I'm going to chair this session, and I'm joined, I'll introduce them fully in a moment, by my colleague Richard Turney, by Caroline McDade of BNP, Ian Gilby and Richard Ford of Pinsent. A few housekeeping points. First of all, you're all muted, so you don't need to adjust any of the settings on your own system. There will be questions and a chance to have a discussion after each of the segments. So as things are going on, please use the question and answer section at the bottom of the Zoom screen. The chat function doesn't work, so use the Q&A button. If you'd like your question to be anonymous, then make sure that you tick the send anonymously button before you send the question. And we'll try and deal with as many of the questions as possible within the time that we've got. This is recorded. And you'll all be sent a link to the recording shortly after we finish today. So if you have to drop off or you can only stay for a part of it, then you will be able to see the whole thing if you wish later on. And no doubt questions that follow will be picked up in webinars by our three organisations thereafter. You can always email any of us, of course, with any questions at any time. If you drop off for any reason, then use the original link to come back, and that should still work. Okay, let's join with our other speakers. Let me introduce the speakers who we have for you today. I've introduced myself. A little bit of further information, I suppose, particularly germane. So today is I practice across all areas of planning. I have had a long and productive relationship with the department over many years, advising on the framework in 2012 and 2018 and various other planning reforms, defending them in the court as well, most recently in the RCA litigation. My colleague Richard Turney, who is a senior junior in Landmark Chambers, his practice extends across the whole planning system, particular focus on strategic planning, on regeneration and infrastructure, particular relevance for today. He's a member of the Attorney General's A panel, representing the government, advising on planning issues, as well as appearing in the court for the Secretary of State and other parties. And he was, to spare his blushes, the Planning Junior of the Year at the Chambers and Partners Awards last year. Caroline McDade heads up the National Planning Team at BNP Paribas Real Estate and Stratton Parker, operating from offices across England and Scotland. She has over 20 years experience advising both the public and the private sector on all matters relating to planning, and she's working on large-scale employment schemes, strategic land and residential development, amongst other things. And then our two speakers from Pinsent, both of whom I'm sure are well known to all of you. Ian Gilby, senior planning partner with Pinsent Masons, heading their multidisciplinary residential sector. Ian's practice focuses on major residential-led and mixed-use projects, including tall tower schemes in London and the promotion of a number of garden villages in England. Ian and his team are advising on a range of schemes that cumulatively will deliver or aim to deliver over 50,000 new homes in England, many of them affordable. And last but not least, Richard Ford, planning and environment partner at Pinsent Masons, specialising in major planning, compulsory purchase, environmental and highways projects. He advises in the real estate, energy and infrastructure sectors and is leading on a variety, again, of garden communities, major town and city centre regeneration projects, urban extensions, greenbelt release, topic we'll come back to later in the morning, local plans, universities, sports, logistics, energy and infrastructure projects, including nuclear, regularly rated, as you will all know, one of the top planning solicitors in the UK. So that's our team for this morning. The agenda for today, you'll see on this slide. I won't read all of it out. I'm going to go first and talk about the overall architecture of these changes in the bill and how they fit in with the wider reform agenda. I'm going to focus specifically on the changes to section 38.6 that are proposed in the bill, and then draw out some themes which I hope will help as we tick through some of the more detailed matters in the presentations. Richard Turney will follow me, focusing on the plan making aspect of all of this, the cornerstone, if you like, of how it's intended to work still, and he will also pick up the interesting changes proposed to enforcement. Caroline is going to talk again about national and local policies, and then drill down into design coding, the interesting street votes data and the resourcing issues for local authorities. And then Ian will talk about the infrastructure levy, Mayoral CIL, what's going to happen in the future, we think, to section 106, and pick up the specific point about heritage. And Richard Ford will deal, as you can see, with the EIA, as it's almost become known already, environmental outcomes reports, their effect on the remainder of the scene, locally led development corporations, and streamlining of the development corporations for new towns and compulsory purchase. So that's the plan for the morning's event. Right, let's begin then. I'll start, and I'm going to introduce you, not in huge detail to the content, because I anticipate a number of you will have read it already, but I will give an overview of what's in the bill and how it sits in the wider context. The overall architecture, I think, is worth dwelling for a moment before I start going through these points on what the context is. We had the Levelling Up white paper, if you recall. Can any of us forget? We're in Brexit, post-COVID recovery, and we're halfway through, aren't we? The Johnson electoral term and the government, and all of those are unsurprisingly directly relevant to the contents of the bill. In that context, I see two related outcomes that the government is seeking through these changes, particularly in the bill. The first is to make England more attractive to investment, both domestic and foreign. And the second is to make all regions or areas of the country more productive. That's the key note across the board, thereby creating a virtuous circle locally and enabling investment decisions to be made more readily. It's easy to be cynical, obviously, about the political background to some of it, but as far as the planning system is concerned, it seems to me that that context and those two outcomes direct what the government wishes to see from the planning system through these changes. And I'd identify for you two things. First of all, creating the planning system to create better the conditions for investment, and secondly, to create the conditions for increased productivity. It's the same knot of points as usual, one might think: faster, more certain, obviously the rule of law, key to the delivery of the whole thing. Pulling against those things, discretion, local politics, national politics, detail, and the ever-present threat of legal proceedings. So all of those things connect to the contents of the bill. And one of the things it's interesting to focus on, even as we're still digesting at this early stage, is we can see where all these things perhaps fit in, but what does the whole system look like? Is it an old dog being taught new tricks, or to what extent is it a new dog? So in the bill itself, we have a front section, which we're not focusing on too much today, on levelling up, the framework for the levelling up agenda. Devolution, hugely important. Planning changes to the plan making system, to decision making, and then aspects of how it will work. The infrastructure levy, the EIA, the development corporations, and CPO. There are many other changes into which this kind of Russian doll, if you like, nestles. The policy changes. So you'll have seen that there's a document called Further Information, as well as the policy document, which is published at the same time as the bill. And those, again, stress devolution and make an enormous point about the system not just remaining genuinely plan-led, but moving even more towards leading from the plan, which is an echo, ghost, one might say, of the white paper the majority of which, as we know, is not in fact taken forward. And you'll have seen, and I direct you to the government's response to the consultation on the white paper, which provides important background as to why we have the things that we have in the bill and why we don't have some of the things that were in the white paper. Perhaps the latter of less importance, but nonetheless interesting to see the direction of travel. I'd also point you to policy changes, hugely important, and on digitisation and the national development management policies, which we'll come to in detail in a moment. So as well as policy changes, a number of the things in the bill will require further law, further regulations, directions by the Secretary of State to animate them and indeed to give put flesh on the bones in many cases. So in terms of timescale, here we are still in May 2022. We're looking, it's difficult to tell, but we're looking at the bill through the rest of 2022, passing into law sometime, it's difficult to tell, in the next 6 to 8 months. And then all of these other things happening around the same time through into 2023. So if one's looking for a stabilization point, if you like, of this new system, we're probably looking at the end of the next 18 months as an educated guess. Thank you. The focus that I want to give on detail is on the plan making system changes, and you'll have seen that clause 83 of the bill makes a couple of important changes, proposes a couple of important changes to the master section 38.6 section on how planning decisions on applications and appeals are taken. So decisions to be taken in accordance with the development plan and this new creature, National Development Management Policies, NDMP. So two things rather than just in accordance with the development plan. So something national as well as something local. Second major change in the section, unless material consideration not just indicate otherwise, but strongly indicate otherwise. Now, obviously, the intention is to, I think it's fair to say, improve plans. We'll come back, particularly with Richard, to talk about those ideas later on, to make them quicker and to make it more plan-led, to make them more determinative. So touching back on our themes, quicker, more predictable outcomes, better for investors, etc. Strongly, what is that going to do in real terms? Obviously, that's going to be a judgment. It's going to require, it seems to me, material considerations to do more than edge out or narrowly on balance, outweigh non-compliance. So the kind of judgment that it is a relatively familiar one from the system at the moment. Obviously, we've got things about clearly outweighing, greenbelt, significantly and demonstrably in the presumption. But it seems to me the real question here is whether this new approach will prevent, or at least be inimical to more up-to-date factors leading to consents in the context of plans, local plans which may be out of date. Because obviously the framework has been the engine which is pulling the whole machine against a dead weight of an out-of-date plan for the past 10 years, is itself a material consideration. So it's now on the other side of the balance against not just the local plan, but also NDMPs. So what does this system do? Question not, I think, able to be answered today, but a question to bear in mind. What does it do to the framework and the presumption? Have they been subtly downgraded in the overall structure? If they haven't, does this change make much difference in the end? So the definition of what an NDMP is, it's pretty clear. I think it's not going to be the MPPF itself. General management policies which the government doesn't want to see constantly repeated and reheated in local plans are going to be in a separate document or documents. In order for them to count as an NDMP, they're going to be direct. There's going to be a direct specific designation or direction of them by the Secretary of State. Now, how that's done, how much consultation, if any, there is on it, how often it's changed, how reliable it is because of the cardinal role that it's going to play in this new system, yet to be seen. But again, the mutability, if you like, of that key new component of the front end of the test is something that we all need to be very well aware of and may want to comment on in the next period. And so will the NDMP affect the weight of the existing plan? So if they're both in the front end of the section, what happens if the NDMP covers areas which are in the local plan and supersedes them in effect by more recent guidance? One assumes that the NDMP will take precedence. But there will be, I'm sure we can all imagine already, instances where a particular project may well have a lot of traction when seen against the NDMP, but may pull very hard against the local plan, could be contrary in some key aspects to the local plan. So the case law that we have about being in accordance with the development plan as a whole is going to morph, it seems to me, necessarily into a similar kind of exercise of judgment as to whether seen together the project is in accordance with those two things, and they may be internally inconsistent in some respects, like policies and plans are. So not a radical conceptual change, but much more complicated, I think, potentially in practice. Thank you. Just a couple of other thoughts on that. Where new forms of governance, which we're going to come on to talk about, are concerned, how does this work? I think that's something just to flag up now for consideration later. And again, one of the themes we'll come to is the balance of power, if you like, between the local plans and NDMPs, locally specific policies in new plans being considered within that context. So we have within the suite of development plan documents now, as I've said, the local plan and the NDPS, actually NDMP, sorry. There's also going to be something we see called a supplementary plan. Now, we don't know a huge amount about that animal yet, but it looks like it's a partial review or potentially an equivalent to an AAP, something of that kind of shortcut or short circuit of the lengthy local plan system. And so they may well be very up to date, very specific. And how will they pull against the rest of the old local plan and the new national set of principles? I think that's going to be, for practical purposes, one of the main areas of activity in the initial period, because we all know how few local plans there are that are up to date, and also how long it all takes if we're reviewing the whole time. It may be advantageous both for local authorities or for developers to bring forward these supplementary plans, or at least collaborate on them, to short circuit the overall arrangement. Now, if that's where the engine is really roaring, what does that do overall to the local plan system? Are we going to have a two-tier system, if you like, with a fast set of supplementary plans and a kind of lag? And if that's the case, what's going to happen to the assessment of the supplementary plan? What's it going to do to the rest of it? Is that going to be part of the consideration of the acceptability of the new supplementary plan? So those are all matters that Richard in particular is going to return to later on. So at the end of my piece, I'd just like to set up, bearing those points in mind and thinking about the particular points on section 38.6 that I've mentioned, some themes. So if I could have my last slide, please. One is, again, it's high level and it's interesting, but we need to think about practical consequences, I think. Where is the balance here? Is it more central? Is it more local? And I don't think at this stage it's possible to say, whether we've tilted a little bit to the centre or more to the periphery. I think it's asymmetrical. I think there will be a variety of different outcomes in different places. There's an enormously important aspect of devolution and funding deals between the government and particular areas, which is likely to drive the outcome here in terms of who's in control. Now, if the government is in control of the purse strings in the end to a significant degree, then one might say that it is likely to be more central than local. The advent of the national development management policies, I'm not sure changes very much in that respect, really, because they're like, we'll see what they are, but it seems to be they're likely to be more like parts of the existing NPPF. But it seems to me that there's going to be a tension more formalized, perhaps, than the one we already have between what's on the surface of policies and what the deals are that are being done between centre and local. There's a very important part, obviously, of levelling up, which is to do with planning. And the more one thinks about it, even at this stage, the more difficult it is to imagine demonstrating, not just through these missions that are referred to, but demonstrating overall that this is working without some form of overall coherence, which is why I mentioned the possibility of a national plan. We've had regional, they've gone. Is there some overall spatial aspect to this, which the government should be considering to make it more overall coherent? And again, what will be quick, what will be slow? That's one of the themes that we need to think about throughout the morning, and to step back a little bit from the practical to the more theoretical. How fair will this be, and what will the public good be from the overall blend that we're going to get? So thank you. Those are my slides for you. We're going to have a short session on questions on that, and I'm going to invite the other panel members, please, just to turn on their cameras for a moment. We have a smattering of early questions. I'd encourage all attendees to keep firing in the questions. We have a question, I think, that I'm interested in maybe seeking Richard's view on, Richard Ford's view on, about combined authorities. So I know we're coming to later in the morning, a spatial and their role in bringing forward spatial development strategies, and whether, if they're produced at that level, will it essentially be a duty or requirement to produce? I don't know whether you've got a view about that question from Grant Jackson.
Yes, thanks, Rupert. Yes, the question is, if a combined county authority is formed, is it the case no authority within the area could produce an SDS? Does this effectively mean SDS can only be produced if the combined county authority is formed, and will this essentially be a duty or requirement? I think the answer to that question is yes. That seems to be the intention, that SDSs will be combined authority SDSs, and if county councils decide to become combined county councils, then that function doesn't seem at the moment to be within their remit. Now, is that sensible or not? And does that need clarification? I think is an important point. I just had a couple of observations on what you said, Rupert, as well, if I may. Just 3 points. The section 38.6 strongly point, very important issue. To my mind, one of the practical implications is that developers are going to have to scrutinise even more carefully the development plan as it comes through, to look at the percentage degree of compliance of their proposed scheme against the plan. Because when you get into tilted balances in that degree, I mean, the number of schemes I've done where we've worked out that our scheme's probably 95% compliant with the development plan, but the 5% is problematic, and now we've got to strongly indicate otherwise for that 5%. Does cause me some degree of nervousness. Yes. The interface with Greenbelt, does it mean clearly outweigh harm and up to the Greenbelt and any other harms is now redundant or not? Or is there some clever interface that one needs to focus on? And then the death of SPDs, which I know Richard will deal with, in the traditional sense of an SPD non-examination nature, replaced by supplementary plans we can usefully debate. So I thought I'd just mention those things.
I mean, I think on the Greenbelt point, if you have established very special circumstances and clearly outweighed all the harms, then the chances of you strongly outweighing any non-compliance with the development plan is almost answered, because the plan is almost certainly going to have a Greenbelt policy in it. Which you would have kind of dealt with, if you like, through your VSC exercise. But I totally take the point, Richard. I think the more you tweak, the more you up the ante on words like strongly, the more overlapping and intersecting judgments need to be made about the planning balance. And I think that is a practical implication. Richard, could I ask, Richard Turney, could I ask you very quickly just to reflect on a question that we've had from Richard Seaman? If you can see that one. The question is, I ask you because you're going to come on to deal with plans for us in a moment. Should there not be a provision, in other words, a legal provision in the eventual act, to cancel a policy in the local plan when it's overtaken by a supplementary plan? I guess in the interest of clarity, what do you think?
Well, that does make sense. I mean, it's probably just worth briefly saying that the supplementary plan sits at the same level as the local plan, in the sense that it has to conform with any spatial development strategy that's above it, but it sits at that local plan level, in the same way that under the current system, AAP or something would sit at the local plan level. So I think you would say the later document takes precedence if there was conflict, I think, but clearly there'd be some advantage if that was spelt out in the legislation. So I agree with the comment, and there's the risk always, isn't there, that the terms of the policy in some further plan document may or may not be inconsistent with the earlier document, and you get into a debate about which one, whether you can accord with both or whether one has overtaken the other one.
I agree. Just time for a couple of others. I did, Caroline, there's an anonymous question here. Not that makes it probably makes it more interesting rather than less interesting, who knows. But it says, are the national development management policies essentially a reintroduction of the old PPSs? And how does that sit with obviously what we did in 2012, sweeping those away? I mean, one might add to that potentially, what's the relationship going to be between those and the famous ever expanding PPG? Do you have a view about that in practice?
Yeah, I mean, I think there is some sort of certainly a move, given the themes that the new national development management policies will address, that they could be similar to the old PPSs. And I saw on Twitter, I think it was yesterday, a number of comments, people nostalgically thinking back to PPSs and which was their favourite ones, and the PPGs as well before that. But I suppose the difference is that the NDMPs will have greater weight because it's part of the development plan, whereas the PPSs were guidance. I suppose it's slightly more akin possibly to the national policy statements that we see that sit in the framework in relation to national significant infrastructure projects and the DCO process. So I suppose it's sort of maybe sitting between the two.
Yeah.
But it's a good point about the whole ethos of the NPPF and narrowing or bringing policy down, guidance down to a limited number of pages. And it does feel that we are going to be going the other way again, and you know, our libraries are going to get bigger.
Yeah.
And I think on that point, I just sort of echo some of the comments that were made just now around observations in terms of the process that we have to go through with planning applications. And as Richard said, we will need to scrutinise the plan more and all the documents that form that. To be sure that, or to test whether we're in accordance with the plan. And it will make planning statements, I think, bigger,
Yeah.
because lengthier because of that. And we might find ourselves scrabbling around a bit more on the material considerations and what other material considerations might fall into that basket if we've got that higher hurdle of strongly in the test.
I totally
so
agree.
I think that's quite a important point.
Yeah.
And I think that's just that to finally the whole framework will differ on depending on which area of the country you're in. There'll be a variety of outcomes as to whether there's a perception that perhaps government is taking more of a role and control over the plan than in other areas.
Yes, I agree. I mean, I think a huge amount, obviously, we're flagging up issues that we all need to be very aware of as the thing comes forward over the next 18 months. We don't know, obviously, at the moment, exactly what these national development management policies are going to be. Are they going to be generic? So don't say there should be good design in your local plan. Or are they going to be a little bit more directory in some senses, i.e. a little bit more like the PPSs? It's a fascinating subject. And obviously, the more directory they are, the greater the possibility of complicated relationships coming into being between the local plan, the remainder of the NPPF, and what's now given this new status as essentially development plan rather than material consideration. Do you want to say anything, Ian, before we move to plans, Ian?
Yeah, thanks, Rupert. I mean, I just as an overall observation, I'm so old now. I remember a Labour planning minister, and I remember sitting down with Richard Cabourn a very long time ago, and he said that they were reforming the planning system to make it fairer, faster, and more consistent. And every government successively has said that they're going to reform the planning system to achieve that. I think what we're looking forward to here is, you know, a period of 2 or 3 years of transition with some uncertainty, and I think that the net effect of that, and one of the challenges that you raised in your opening, is whether this will lead to greater investment and economic activity. I think in the short term, it will make probably little difference. But I think as the regulations and policy that sits around the bones of the proposals in the bill come forward, that there will be taking stock. And I would encourage the department to act swiftly in delivering those policy documents and those draft regulations as soon as it can, because the bill sets up a framework, but like so much in planning, you need to understand what flows from that to see how that will affect commercial investment decision making, and also for local authorities, really, in terms of the resource implications that much of this will have, particularly in relation to the plan making element, as Richard Turney is going to go on to explain. So it isn't called a planning bill, but I mean it kind of is, and therefore, you know, it will create uncertainty for the planning system in the medium term, but we need to just keep clear heads and work our way through the detail when it emerges.
Yes, thank you, Ian. Well, I think you've had a number of trailers there, Richard Turney, of your paper, which we're now going to your presentation, which we're about to move on, focusing on plan making. So, can I invite you to give your thoughts, please?
Thanks, Rupert. Clara, if you could put those slides up, please. So I'm just going to deal with the plan making section quite briefly, because I think there's probably more room for debate at the end of this. Firstly, just to take you through it, the plan making arrangements in the bill. We're looking at major changes to the structure of the plan-led system. They're set out in part 3 of chapter 2 of the bill, clauses 82 to 91, but don't be beguiled by the few clauses there, because schedule 7 is where the real fun is had in this part of the bill. If we can go on to the next slide, please. And sorry, the one after that. So this is the new development plan for the purposes of section 38 of the 2004 Act, and Caroline will say a bit more about this when she comes on to look at the application of this all in practice. But we have a spatial development strategy where it exists, an SDS, a single local plan, so one local plan, not multiple local plans, neighbourhood development plans, and then supplementary plans, this new beast, which I'll come on to, a minerals and waste plan potentially, which I'm not going to say anything more about, and then a policies map, a new mandatory requirement to have a policies map. Next slide, please. So spatial development strategies first. So just very briefly, a spatial development strategy is going to exist in, I think, 3 different contexts. One of them is London, where there's the specific provision that we already know and love for the preparation of the London plan. And I'll say a little bit more about that in a moment. Then there's the combined authority. And then there is a separate provision, new provision, that allows the preparation of a spatial development strategy in an area where there's no combined authority and you're not in London, and it effectively allows 2 or more local planning authorities to combine to adopt a spatial development strategy. Broadly speaking, it looks like the London plan, in terms of its scope, it's supposed to set matters of strategic importance for the area, and and there's a process for its preparation, agreement between the authorities for its preparation, and then a plan making process which aligns with the local plan making process. I think it's probably just worth mentioning rather negatively the process for withdrawing from the SDS. So notably, before the SDS comes into effect, a planning authority that is in an agreement to prepare a spatial development strategy can withdraw by making a resolution to that effect and giving appropriate notice to the other authorities. If you still have more than one authority, then they can proceed in certain circumstances with their SDS if you have more than one left. Of course, if you only had two to start with, then the withdrawal of one brings to an end the SDS process. In terms of withdrawal after the SDS comes into effect, important point to note that there's basically a 5-year moratorium on withdrawing from the SDS. So it's not open to a planning authority unilaterally to withdraw from an SDS for 5 years after its adoption. The authorities acting together can withdraw the whole SDS, and indeed the Secretary of State can direct its withdrawal, but there's no unilateral action for the first 5 years, which may of course disincentivize the preparation, knowing that you're bound by it without any flexibility. The local plan is effectively must accord with the policies in the SDS, so they are the higher level plan. The content of the SDS effectively, as I indicated, mirrors what is in the London Plan process. It is strategic policies, and I'll say a little bit more about that now. So can I have the next slide, please? So the London Plan system in the 1999 Act is slightly rewritten. The language has changed, so we're no longer going to have the distinction between adopting plans and publishing the London Plan. In terms of the restrictions on the scope of the spatial development strategy for London, and this is the same for the new SDSs, they may not specify particular sites where development should take place. So that's a new restriction in the London Plan, in the London Plan making process, which will also apply to all SDSs. So they're effectively common provisions. In terms of the other refinement for the London Plan, there's an added definition of what is of strategic importance, i.e. what is legitimate content for the London Plan, and that is that it has to have an effect in more than one borough. So you can't say something of strategic importance unless it has that effect. Next slide, please. So then we'd go to the next tier, the local plan and supplementary plans. I think probably the first point to note is that the local plan is now a single local plan. So whereas lots of authorities at present will have multiple local plans, different tiers of local plan, part 1s, part 2s, the idea of these provisions is that there will be a single local plan. That can then be supplemented by the supplementary plans. Now I'll come on into a bit more detail on those because they're a new thing. There's also a requirement to prepare a plan timetable, and there's an indication that the government will give further guidance on timetables for plan preparation. And there's a new requirement to have a policies map. So that's an express requirement. Obviously at the moment, maps can be part of the development plan. There's now a requirement to publish and keep up to date a policies map. Next slide, please. So supplementary plans, they are fairly broad in content, and they sit alongside the single local plan in the sense that, as I've already mentioned, they have the same status in the development plan hierarchy, and they may specify the amount of development or the location of development in any particular area, so the sort of site allocations type policies. They may specify various objectives in respect of design. They may identify infrastructure requirements, and there's power to prescribe what else may be or may not be in a supplementary plan. Now, the point that's already been raised in the question and is of some interest is, does this replace SPDs? That's certainly what the government says it does. the indication is that supplementary plans will be instead of SPDs, which are criticised in the explanatory notes and in other publications from the government as having uncertain status. Now, the bill itself does not get rid of SPDs because, as you will know, they are provided for in the 2012 regulations. Whether those regulations are going to be withdrawn or amended, we will have to wait and see. But certainly the intention is that supplementary plans replace SPDs. I suppose the point worth noting, and perhaps for discussion, is that the removal of the power and the particular duties in respect of the adoption of SPDs does not, of course, prevent an authority from saying something else about its planning system, which may then be a material consideration. That may be a relevant factor. The other point to note, of course, is that the amendment to section 38.6, which we're going to look at a bit more, means that the weight that would be given to SPDs is going to be reduced anyway, because they are not part of the development plan. So the relationship there, I think, is one which probably needs some further consideration. Then moving on to the next slide, please. Plan examination. We're told that the examination process is going to be made quicker and easier. Just a few points from the legislation, and I think more to come in guidance and so on. The soundness duty is maintained. So there's still a duty to, that's still the purpose of the examination, to work out whether the plan is sound. However, there's a promise that soundness test is going to be re-examined. There's this express provision for pausing examinations. There is a restriction on the power to withdraw from examination. And this is quite important because, as you will know, many plans come a crop up during the course of examination, and there's a decision by the local authority to withdraw entirely and effectively reset the plan making process. So that power is restricted. For supplementary plans, the examination process is intended to be written only. That's provided for in the bill. The other point to note, and obviously that's caused some excitement, is the abolition of the duty to cooperate. That is to go away. It is going to be replaced with a further duty, which is an alignment test to be set out in national policy, more detail to follow. And there's also a new power, a power to require assistance from other bodies in making a plan, which obviously is intended to shake statutory consultees and so on into action to ensure that they don't delay the preparation of a plan without naming any names. Neighbourhood planning then, next slide please, very briefly given the time. I think probably a couple of points to note. The first one is a provision for a new neighbourhood priorities statement. This is a sort of neighbourhood plan light, where the planning area, the neighbourhood area, has not got round to adopting a neighbourhood plan. They can adopt a priorities statement, which can address general points about the scale of development in the area and its overall strategy. And those are relevant in the plan making process. So in other words, they can inform the local plan process at the higher tier. In terms of neighbourhood development plans, the idea is that they effectively continue much as they are, although there are certain new restrictions imposed. So the idea is that neighbourhood development plans won't be able to stop housing provision which has been identified in the local plan, nor will they be able to alter the overall scale of housing which is identified in the local plan. So those are effectively two new additional basic conditions for neighbourhood development plans. So that's plan making. If I just go into the next slide, please, and the one after that, I've just very briefly dealt with enforcement. I think probably we don't have much time to discuss it, but there are some changes to the enforcement provisions in the Act, which obviously will be of interest to some practitioners. Probably the highest profile one is the loss of the 4-year rule. So the proposal is that every breach of planning control will be subject to a 10-year limitation period. But I'll leave those other ones on the slide and open it up for discussion.
Thanks very much indeed, Richard. We have had a number of questions, and I'll attempt to deal with a number of those and put the points to our panelists for about 5 or so minutes, and we'll come back at the end to a wider discussion. I wonder, just focusing, Richard Ford, perhaps on this point about the fate of SPDs. I mean, a lot of SPDs are thematic, as one of the attendees raises in their question. What's going to happen to those? Is there still going to be a role for a thematic supplementary planning document?
Well, probably not. Not to a huge extent. I mean, as Richard Turney said, if we are replacing, as the government's indicated in the explanatory notes, SPDs with supplementary plans, then supplementary plans themselves could be thematic, obviously, but in terms of, let's call it, that has to go through examination, of course, and that will slow things down. So it's a bit of a double-edged sword, really. Some local authorities like SPDs because they can quickly elaborate on policy via a non-examination process. But developers sometimes don't like that because it's not properly scrutinised, obviously, in examination terms. So in, let's call it, quick fire thematic SPDs are probably dead in the water if it's followed through, which I think it probably will be in terms of amendment and withdrawal of those regulations. But the ability still to do thematic supplementary plans will still be there. What the guidance will say, because you have a single local plan, of course, normally when you had an AAP and you had those baskets of development plan documents, which are no longer going to be the case, it was more area based rather than thematic based in the DPD sense. The SPDs were the ones that dealt with themes. So we've got this kind of new creature of a sort of local plan document that could potentially be more thematic, but was traditionally more area based. So it'll be interesting to see what happens.
With you. Let me, before I come to Ian briefly on that point as well, can I just mention that for the rest of it, we're going to have a little poll for you attendees to participate in if you wish, relating to each of the papers. And we'll just start that one in relation to Richard's paper now. We'll just pick up the results at the end of this short chat on Richard Turney's paper. So Clara, if you wouldn't mind just putting that poll up. And we can see it running through. We'll come back to the answers. Ian, did you want to come in on that point that Richard was covering there?
Yeah, thanks, Rupert and Richard. It's a really important point that Richard Turney raises and Richard Ford added to. There's a number of projects we're involved with where the local planning authority has sought to add a kind of further layer of plan making through vision documents and master plans, which aren't then subject to any scrutiny as SPDs. So I think we'll continue to see that. What I'm hoping is that this new system will outlaw effectively that kind of further layer of policy, because it's unhelpful, I think, for local communities to understand the status or changing status of some of those documents, and it's certainly unhelpful for developers and investors who are asked to tackle documents of unknown status. So I think a codification of that local plan making process with proper transparency and certainty should be a good thing, and hopefully we'll see less informal policy being promoted, which I think creates uncertainty for everybody involved.
Yes, thank you. One of the questions, it's reflected in a couple of the questions actually that people have raised. Maybe Caroline, I come to you on this, is where in this new constellation, if you like, of documents, we're going to find the housing numbers being set out. Do you have a feeling about where we might find those in the end?
Well, there was a bit of ambiguity, I think, when both the bill and the further information, etc., was published last week about where Mr. Gove was in terms of the 300,000 target. I think he has now clarified that as still being the target, but down to the sort of nuts and bolts of it, certainly the sort of housing plans are not set out in in the bill or really in the supporting documents, explanatory documents and policy at the moment. I think there will be further information provided, but particularly on things like the standard method. But it's very, at the moment, it's very vague on that point.
Yes, and we know that the extent to which one's going to have to rely or be forced to rely on the standard method, and whether there's going to be an exceptions test, if you like, that is still up for grabs in policy making over the next period. But it's one of those points, I think, that, okay, maybe not a fundamental criticism that it's not absolutely pin sharp at this point, but it needs to be in the end, doesn't it? Because otherwise we're going to end up with a ramshackle system that doesn't lead to clarity for investors and local people as to where this is all going to take place. I'd like to come quickly back to Richard, if I may, Richard Turney, on questions about infrastructure, really. I mean, we know, don't we, that infrastructure is often more than local. It's often the way to unlock, the hearts and minds of local people if they can see there's going to be the road and the hospital as well as the 5,000 houses, etc. Where in this new system do you think the burden is going to fall on providing this infrastructure? Is it the spatial stage or lower, or what do you think?
Well, I think it should be the spatial stage, shouldn't it? I mean, that's the vision. I think that the mayor or the authorities acting together to have an SDS together will say what the infrastructure needs of the wider area are, and that will be the means by which they're identified. Yeah. In reality, I think probably there are going to be a large number of areas we could probably between us draw a map straight away where there aren't going to be SDSs. They're just not going to get to the delivery of an SDS. And I should say that joint local plans still exist under the new system. So they're those authorities that currently are joint planning. They may just adopt a new joint plan. They're not forced to go to an SDS. So infrastructure, I think probably SDS ideally, otherwise local plan. The supplementary plan expressly is identified as being a place where you can put infrastructure requirements. But as ever, the real questions about infrastructure don't really turn on their identification in a plan. They turn on their identification in a bank balance somewhere. Yeah. So I think ideally it's at the top level, but probably realistically it's coming at the bottom level, if at all.
Sure. Okay. I think we'll just call a halt to the questions and discussion on Richard's paper in terms of time, and I'll bring you up to speed with what you voted on the poll. Richard, can you see that? Would you like to deal with what the answer was from our attendees? I think about 500 of you answered.
So yeah, it's about a third saying yes, it will be more effective, and 2/3 saying no, it won't be. But I guess everyone is guessing a little bit, aren't they, at the moment? Yeah. And maybe it's one of those situations where the reality is it's the other things, such as the consequences for 5-year housing land supply, that are more likely to stimulate action than changing the legal architecture.
Yeah, and as you say, a change even on this scale, not the white paper scale, but this scale is going to have transition, and it's going to take quite a long time to bed in. So as Ian, I think, said, or Richard said earlier, it's going to lead to 18 months, 2 years of bedding in an uncertainty where local plans may be slower rather than quicker. So they've said, the government, 2030 horizon for levelling up. It may take, if all goes well, to 2030 to get this new system in place. Okay, thank you very much, Richard, indeed. We'll turn to Caroline McDade, if we may, for her presentation. Thank you.
Thanks, Rupert. I don't have much time and a lot to cover, so it's going to be a very quick canter through everything. Next slide, please. As Rupert touched on, I'm going to cover these 5 issues. Next slide, please. As we've had quite a lot of debate already this morning on, one of the biggest proposed changes in the bill is the new national development management policies. And that is, as discussed, a proposed suite of national policies covering generic topics like heritage and flood risk and greenbelt, etc. And the bill's aim and the government's aim is to make the planning system more streamlined, and in bringing forward these national development management policies, and I assume shortening the NPPF and PPG, and taking the sort of duplication of policies that potentially would happen out of local plans. That creates a more sort of, or a clearer sort of tier of development plan structure. But it's still a little bit unclear at national level what that's going to look like. And I like a bit of detail, so I'm sort of trying to envisage what it might look like. It's 2 documents. One is statutory, which is the National Development Management Policies, and the other, which is material consideration, the NPPF and PPG. I'm not quite sure how, that's going to sort of sit together as one or 2 separate documents, as I said. But the important thing is that the National Development Management Policies have the same weight as the development plan, and actually, interestingly, trumps the development plan where there is conflict between the 2. So the detail on this will be set out in a prospectus NPPF consultation document at the committee stage of the bill reading. And just picking up on Rupert's question around housing supply, that should at that point also address the planning for housing issues, such as the standard method. And I think we'll probably come on to talk about abolishing 5-year housing land supply where there are no plans up to date. And interestingly, everything seems to be silent at the moment on the housing delivery tests. So it certainly seems to be there's a lot more detail to come. The concerns I've got, I suppose, around this new system is that there does feel in part or in places there's a move towards a more zonal system akin to perhaps the white paper aspirations, but certainly providing potentially less flexibility in decision making, as we touched on, and perhaps more consideration needing or emphasis needing to be given to that basket of other material considerations. And the other reason that I'm sort of thinking along those lines is if you look at the call for evidence to the House of Lords Select Committee on land use, the questions in there sort of start to hint around perhaps a more zonal approach to the system. And in some cases, there may be a more centralising of power and planning as well, because the ability to make changes to development management policies at national level is possible without consultation, although this was denied by Stuart Andrew, the Planning Minister, this week. Next slide, please. So design and beauty formed a large part of the planning white paper and dominated the headlines in August 2020 when it was issued. And it now seems to form a key pillar of the government's levelling up agenda in helping to restore a sense of pride in places. And this continues the department's work on setting up the Office of Place, addressing the recommendations in the Building Better, Building Beautiful Commission report, and the subsequent issuing of the National Model Design Code. Reflecting the importance of design, the bill now proposes that area-wide design codes are required at local authority level, and these would either be adopted through local plans or in the as a supplementary plan that Richard was talking about, and they will have full weight in decision making. So the National Model Code template that is available, which provides guidance on the production of codes, I think will be a useful starting place for many going forward if this bill is enacted. I think there's going to be potentially some practicalities in complying with the mandatory design code. If it's for a whole local authority area, some local authorities are very large in their the extent of their boundary. I'm thinking of sort of Buckinghamshire Council, for example, and the character of South Bucks is very different to that of North Bucks and Buckingham. And design is subjective, and if the quality of the code is not up to scratch, it will make it difficult to comply with, and therefore fewer planning permissions will be granted, which subsequently, if we're looking particularly around the pressures on housing, is going to be an issue. And I can remember, I'm old enough to remember back in the day when local authorities had design officers. Fewer of them do now, and so I think there's going to be a need for many local authorities to recruit design officers in-house. And I know that the department has been working with some local authorities with the Pathfinder Design Code initiative, which will help. Anyway, design is here to stay. I think that's the sort of key message, whether it be in the national development management policies, in local plan, in supplementary plans, and then potentially, particularly for big sites, as we've had to date, at site sort of allocation level, planning application level too. Next slide, please. Street votes. This idea has been heavily trailed in the papers, but we still don't seem to have an enormous amount of detail on it, just a placeholder in the bill. The proposal, as I understand it, would allow residents to extend or redevelop their properties in a street in line with a set of design preferences. If the development rules are met, the proposals would be put to referendum of residents on the street, and that would determine whether they should be granted planning permission. Because of the lack of detail, I've got so many questions around this. For example, how do you define a street? And one of the areas that we've looked at in sort of responding to the webinar this morning is actually the private members bill on street plans, for perhaps some of the answers on that. The bill suggests that the regulations would prescribe things like the definition of a street, what maximum parameters might be appropriate, and the numbers of houses that could be involved. But to me, it seems to fall back to the construct that this could be just potentially another way for households to secure extensions on their houses, and question the benefit of that over using existing PDR route, permitted development rights route, because we've still got to go through the planning system. I suppose one of the benefits that might arise is that in neighbourhood plans, if you could have some of these sort of street votes and streets where this system is in place, and that aligned with the design code, might actually enhance the quality of a neighbourhood plan and subsequent development in that street, rather than getting the sort of piecemeal outcomes that such as the one that's in my photo there on the right of the screen. But I think the conclusion is that it's more likely to just enhance value of existing properties than really add much to the sort of housing supply debate. Next slide, please. So the bill is, I think, delivering on the planning white paper aspirations to shake up both the way we engage with communities and run our existing sort of development management functions in local authorities and the submission of planning applications. The principal sort of foundation and aspiration in the white paper and the bill is that data and automation will make the planning system quicker, more predictable and more accessible. I think we're all pretty used to the planning portal now. It has its odd niggles, but generally okay. And there's got to be a benefit to improving transparency for the public. They will be able to track land ownership and also transactions of land, but also able to search planning applications in their local areas. The screenshot on the right of my slide is the department's prototype for the national map of planning. It's a really quite interesting platform, and I would recommend, if you haven't had a go, to have a play around with it. having a national map with all the data sets in it, so you can click on an area and see immediately where the list of buildings are, where planning applications are, any housing data all in one place, to me, is a really a no-brainer. And although sort of this digitisation forms a big part of the bill ambitions, we're still going to see the more traditional forms of engagement remaining. So things like the yellow site notices aren't going to go anywhere soon. But I think we can all agree that the standardisation of local plans, proposals, maps, planning applications that the bill sets out is very much welcomed and should make life easier for all of us. Next slide, please. So lots of changes proposed to the planning system in the bill, some of which are quite exciting. But there's definitely a cost associated with those at a time when our public sector resourcing is extremely stretched. I suppose the key response by the department in the bill is to increase planning application fees. And for major developments, that will be over a third of an increase, and retrospective applications, 100% increase, although this is all still subject to consultation. The bill also sets out other sources of charging, so we might see some statutory consultee advice being charged for in some instances, and also assessing and monitoring environmental outcome reports. I think that the benefit is that, as I was talking about in the last slide, digitisation and the use of technology will help free up officer time over time. There was actually a suggestion from an ex-planning officer that removing the 5-year housing land supply test might reduce speculative applications in his area that were run on that basis, which would free up a significant amount of senior officer time in those authorities. But there are also, sort of more burdens that the bill is placing on local authorities, not least from the proposed infrastructure levy. There was a suggestion in the white paper, I think, around flexibility over how local authorities spent the levy once the core infrastructure needs were met, and question whether that could have gone on resourcing. There's no explicit reference to that in the bill, but there is a clause that allows them to retain the power to amend the definition of infrastructure for infrastructure levy purposes. So maybe that's a workaround. Finally, also the big concern is that any revenue generated through these changes is still not ring fenced for planning and could go to other authority needs, and that really needs addressing. And finally, we all know that we've got an industry-wide shortage of planners. The RTPI and others have started apprenticeship programs and initiatives which are very much welcomed, but we've still got a bit of a way to go on that. And that's me.
Thank you very much indeed.
Thank you.
Thank you, Caroline. There is a poll, I think, in relation to your material as well. So, Clara, if you wouldn't mind launching that for people to participate in. We had about a 50% just above response rate last time. I'd urge everyone to take part so we can see a full spread of views. So do you think compulsory design codes will ultimately improve design quality is the question. Let's just take 5 minutes and pick up a couple of points from that. Can I just start, Caroline, by reflecting on your point about assuming that all of this will mean the shortening of the PPG. I mean, I can't tell you how fervently I hope that will be the case, but it's often used, isn't it, to backfill and evolve things as practical issues arise. So one wonders, frankly, whether that's going to be the case. The other point I wanted to reflect on was the provisions allow any document to be designated one of these new NDMPs, which have the statutory priority along with the local plan, because the wording is however. And so I wonder whether we're going to have included in those potentially written ministerial statements, which, as we know, play quite an important role. If you think about first homes, for instance, which is front and centre in a lot of big schemes at the moment. So there may be a role for those, and so one will have to keep track of in each area of what's got the statutory priority, the local plan, supplementary plans included, and the national development management policies and other things which have been designated. So it's complex, I think it's fair to say. But could I just come back to Ian? Lucy Howard's asked a question about whether there's going to be in the NDMP anything about specific AONB or national park policies. Do we know at the moment? Have we got any hints about that?
We don't know, but I think it would be helpful. I mean, I think the intention for the new national development management policy to deal with heritage is certainly signposted, and you'd expect other important designations like AONB to be dealt with in that way. I mean, one of the problems with AONB is that there is an inconsistent approach through the country as the various bodies are involved in managing, designating and improving NOBs operate in a slightly different way. So I think we're going to get more clarity on overlaying heritage policy. I think we're going to get more clarity on overlaying AONB policy through the national management policy layer. And I think also for green belts as well, there is signposted in the accompanying policy paper an intention to further green belts, which I don't think is a landscape designation reference. I think it's more to do with improving access and biodiversity net gain through those green belts. So I think, I mean, I'm cynical at heart, Rupert, but actually I think there is an opportunity for the layer of national development management policy to be a good thing. And I think there is the hope, I think, of some consistency there through the planning system. So yeah, I think there's an opportunity to do something consistent on AONB's green belt and heritage.
I want to make sure that we don't run out of time, so I'm going to cut the only other question I'd like just to reflect on now. Richard T, if I can come back to you very, very quickly on this one. Thinking about design, we know how important it is, how judgmental it is. Design codes are obviously part of this general theme about clarification, simplification, certainty within the process. But where's the design code, do you think, going to sit in all of this structure? Is it going to have not going to have a statutory status?
Well, it's one of the matters that needs to be dealt with in the local plan. So, yeah. but the supplementary plan can also deal with matters relating to design. So the code I think should be in the local plan level. But I think we'll probably see supplementary. Well, who knows? We may see supplementary plans which say, and here is this particular site or collection of sites or areas. This is the form of development, and these are the design principles that will apply to that area. That would seem to accord with what's in the provisions.
I think that must be right. When you think about combined authorities and aggregation and agglomeration, the more you build up and put together, the harder it is to be specific, obviously, across a whole area. So the more likely you are to get a whole series of different design code principles for different parts. If you're, Greater Manchester and the 9 or 10 authorities, whatever it'll be in the end, one size doesn't fit all, does it?
That's right. Although it might be worth just an added complexity is that supplementary plans can also be joint documents. So you could each have your own local plan and then have a supplementary plan that cuts across the whole area, or multiple areas. But that seems improbable, I think, on design matters.
Yeah, I agree. Okay, let's move on. I'll just note you can probably all see the result. Thank you very much for participating. 67%, broadly the other way around from the first poll. More positivity amongst you all about compulsory design codes, which I have to say personally I agree with, but it's just getting them in place, isn't it? That's the challenge. Okay, thank you very much, Caroline, indeed, for that. And let's move on, if we may, please, to Ian, I think, who's going to be presenting the next paper. Thank you.
Thank you, Rupert. If we can have the slides up, please, Clara. And the next slide, please. So I think I should start by saying the good news, I think, is that the new IL infrastructure levy, they really should have come up with a better acronym, but anyway, the new infrastructure levy has the promise of being better than CIL. It's probably a good time to remind ourselves that the CIL regulations go back to 2010. and have been amended 10 times, which I think is probably a record for a set of planning regulations in a relatively short period of time. So we hope that lessons have been learnt in what was essentially applying a tax regime to the built environment. And if CIL was debatable about whether it was a tax regime, then there's no doubt at all that the infrastructure levy is a tax. But it may be simpler, and it may be none the worse for that. So some initial points really on what we know so far, based on the bill and the accompanying policy document. The new infrastructure levy will replace CIL, save for Mayoral CIL in London and CIL in Wales for the time being. It's similar to CIL, I think, but different. There are a number of key differences. Homes England, or the HCA, will be a charging authority, which is an interesting move, and I think signals the power of Homes England in terms of its delivery and ability to make schemes happen under obviously new strategic leadership of Peter Freeman there. There are wide rate setting opportunities to allow for a more granular approach at a local level. We've obviously got the opportunity to nil rate strategic schemes at the moment, but there's more flexibility under the new system, which I think is helpful. And the biggest change is that the levy will be charged by reference to value, not a viability informed flat rate. So in effect, it is what we were promised by Kate Barker 15, 20 years ago, which is a planning gain supplement. It's a tax payable upon the uplift in land value achieved through the planning process. And the other important point to note is that affordable housing can be funded, will be funded, and thereby delivered through the new levy. Whilst that was theoretically possible through CIL, it was never switched on. Whereas the starting point with the infrastructure levy is it can and will be used to fund affordable housing through a variety of means. Next slide, please, Clara. Important also that the levy will be mandatory, unlike CIL, where there's been sporadic take-up, especially outside of the London and the other major urban areas. But I'll come back to that in just a moment, because it's not going to be automatic and won't apply automatically across the whole country for the time being. In the run-up to the bill and through the white paper and what preceded it, the death knell of Section 106 agreements was sounding loud and clear. But I think as a result of lobbying, consultation responses to the white paper and through other mechanisms, 106 agreements have been saved to deliver infrastructure integral to the operation and physical design of a site, so site-specific matters. And also, importantly, to support delivery of the largest sites. And those big strategic sites, whether that's urban regen, garden village, garden community projects, they need that autonomy to provide social and physical infrastructure. And hypothecating that into a tax system with unknown delivery outcomes and timing would have been a retrograde step, I think, in terms of certainty for local communities and local authorities, as well as those promoting and delivering those schemes. So that is a welcome step back from what seemed to be proposed by the white paper. And again, for those large sites, infrastructure can be provided on an in-kind basis. And again, that reflects the current system where much affordable housing, schools, doctors, surgeries and health hubs, etc., will be delivered in kind on site, and the value of those will be taken into account and recorded through the planning obligation of the Section 106 agreement to make sure that those are delivered through the scheme. The proposal here is that those in-kind provisions must not be less than what would otherwise have been paid through the levy as a financial payment. So if there is a degree of in-kind provision, that together with any levy payable must be no less than would have otherwise have been paid through the calculation of the levy. Next slide, please, Clara. Again, as I said at the beginning, the important change is that the levy will be calculated by reference to the value of the property rather than a notional viability set at the rate setting stage. I think that's a really welcome change, subject to some detail. That the problem with the hypothetical viability process is it's set at the charge setting stage, and then can often really bear no relation to individual site characteristics and circumstances, either really at the point that the rate is set or later on when the proposal for development comes forward. And that can often lead to a very lengthy delay whilst viability is discussed and complex Section 106 mechanisms for early, mid and late stage review are put in place. So on the face of it, the new system linked to an end value slice of value has the hallmarks of being simpler and swifter, but we'll come on briefly to think about that in just a moment. As I said before, differential rates through a local authority area will be possible, and I think that's helpful. And the levy will be collected on the basis of a gross to minimum value uplift rather than by reference to floor space. I assume by reference to a percentage, but again, we'll need to see what the regulations proposed. The government policy paper that accompanies the bill puts forward a number of perceived advantages to the new system, enabling developers to price those contributions in acquisition, allowing more flexibility to reflect those actual increases in value rather than by reference back to a notional viability. And again, importantly, and I agree with this, to fund affordable housing. But there are some obvious questions which will need to be considered. At the moment, the way that the proposals work, the levy will be payable on the sale of an asset, the sale of the property. And of course, it isn't as simple as that. Assets can pass through a corporate sale, disposal, and indeed for example, build-to-rent operators or those with a funder on board looking for a long-term investment, the properties may never be sold at all. And what about registered provider-led schemes where there's a long-term stewardship vehicle in place? Again, the ownership structure may not allow for that asset to be sold and therefore for the levy to be triggered. So the definition of sale will be a critical definition when we get to see the draft regulations. Next slide, please. So again, the infrastructure levy really is an example in the bill's proposals where we need to see the detail to understand whether this system will be better than the old system. The calculation methodology will be key. The new proposal for a right to require, so effectively local authorities can set the amount of affordable housing that will be delivered on any given site rather than relying on a negotiation to set that. That of course will create pressure on other Section 106 matters that may be required. As I mentioned before, registered providers have an important role to play here. How will they be dealt with under the new system? And finally on this, to note that sites permitted before the introduction of the new levy will continue to be the subject of SIL and Section 106. So until the new regulations are in place and until those sites coming forward have been permitted under the new regime, the old regime will apply. Final slide, please, Clara. The final point I want to make on IL is that it won't apply day one to the whole of England. It's going to be a test and learn process, I think, perhaps reflecting the problems with SIL, and it will only be rolled out nationally over several years, allowing for monitoring and evaluation in order to make the system as best as it possibly can be. Thank you, Clara. Briefly, heritage, if we can go to the first slide. A couple of quick points to make here. I think, as I said just now, we're going to see a layer of new national development management policies applying to heritage, which I think is a positive move, and a harmonisation of the statutory approach to paying special regard to heritage assets will now be applied to scheduled monuments, registered parks and gardens, protected rec sites and World Heritage sites. Those were protected under different provisions and different regimes, but we're going to be seeing a harmonised approach to those, bringing them into the conservation area and listed building structure that we have at the moment for the first time, which I think is helpful. And the final slide, please, Clara. Importantly, the desirability of preserving is expanded in relation to listed buildings to preserving or enhancing, reflecting that which applies to conservation areas. And there are new provisions in relation to enforcement, whether by way of a temporary stop notice or whether by way of undertaking urgent works and recovering the costs of doing so. And the final point is this new requirement to maintain up-to-date historic environment records. Thanks very much, Clara. Thanks very much, Rupert.
Thank you very much, Ian. There is a poll. Let's get that started on this one too. Though, again, Ian, I tend to agree with you. I think overall, generally in the right direction. The detail of staggering complexity, I think there's no question about it. And also asymmetric across the country, as you indicated. So how does it sit with levelling up? It's a big topic. Conceivably the most important of all of these topics, I think. So we'll reflect on that at the end as well. There's the poll. Thank you for your contributions on that. Just quickly, could I pick up a couple of the points that people kindly have raised in their questions? Richard Ford, could I ask you just to take an overview briefly about how, a lot of questions on this, what's the relationship likely to be between ill and affordable housing?
Well, I think it's a very good question. I think authorities who are collecting in the cash for affordable housing will have choices to make as to how the affordable housing is delivered. Will they look to developers to do it in kind? Will they look for RPs to deliver it, or will they look to deliver it themselves with their own local housing companies? And we might see quite a lot of market differentiation between authority areas. And I think that will mean developers needing to scrutinise what approach local authorities are going to take to that. Obviously, for the larger sites, is 106 still going to deal with affordable housing as opposed to ill? It's quite an important point. Obviously, that's allowed for. And if that's the case, then we may see, very much as we do now, developers and RPs delivering that. So I think, to be honest, there's going to be a lot more flexibility, a lot more choice about how affordable is going to be delivered. But what brings that with that is uncertainty for developers and the market as to how it might vary between authority areas.
Yes, I entirely agree with that. I mean, do you remember that expression or that phrase that Bill Clinton used to use about "it's the economy, stupid"? Remember that? The more we talk, the more I think it's about infrastructure, stupid. All of this in the end, because it goes to housing delivery, it goes to whether the plan works, it goes to ill, obviously. I mean, Richard Turney, one thing that I think was relevant to yours and fits in here is this point about the IDP, the Infrastructure Delivery Plan at the local level. Where just remind us, where's that? How's that positioned at the moment in the emerging thinking?
Well, I mean, that's all part of the plan process, the single local plan process, but it's another thing that needs to be in place for the authority. But as we've already said, query how that is going to be dealt with when you've got spatial planning happening as well, how you're going to marry up those various documents. And of course, infrastructure delivery plans as they exist at the moment in various different forms cover a sort of range of different things, don't they? You get ones that just say we need some schools, and others that say we need this road to be dualled and a new junction in this location. So they can go from the highly specific project to sort of generality, and presumably they'll continue to have that sort of character.
Yeah. Finally, before we turn to Richard's contribution, can I just come back to you, Ian, on that point about affordable and provider-led schemes, multi-phase schemes, potentially extending beyond the plan period and so on. Are those cases where affordable are more likely to be dealt with by 106 rather than IL, where it's difficult to fit it into the model?
Yeah, I think so. I think also there's some challenges around procurement as well. I think if the local authority are going to collect TIL and spend that on affordable housing, whether on an individual scheme or on a pooled basis, I think there's a relationship here between the funding process and procurement process and value considerations as well. And I think that needs to be worked through. I've also just a very quick point on infrastructure delivery strategies, just reflecting on what Richard T was saying. These are now going to be embedded in the system. And importantly, the infrastructure delivery strategies are going to require the assistance of infrastructure providers and other bodies. So whether that's utility providers, highways authorities, etc. I think that's really critical, because if money, if more money is going to be raised and the new system relies on local authorities to deliver the infrastructure through various means, in kind perhaps is part of that, but there will be other means. It's critical that there's liaison between authorities and those other infrastructure providers. Yes. And my experience on big schemes at the moment, I'm probably shared by other panelists, I'm sure, is it's very difficult to get those infrastructure providers to collaborate, because they're under-resourced and the planning system isn't something that they generally understand. So I think there's going to need to be a step change in that collaborative process if the infrastructure delivery strategies are going to be of any meaningful use.
Yes, agreed. And as you hinted, no doubt a price to be paid for the greater cooperation and quicker cooperation of the stats and so on on this planning. Okay, that's very kind. Thank you very much, Ian, for that. We'll turn to Richard in the moment. Note, it's interesting, isn't it? Most of these polls are coming out 2/3 to 1/3 one way or the other. On this occasion, as you can see, a positive, generally positive view of whether ill will be for good, as it were. Let's turn finally to Richard. We've got time. I'm very grateful for you all hanging on. We will get through, and we will have some questions and answers at the end. So there's no rush, Richard. Can we turn to your slides, please? Thank you.
Thank you. So I'm dealing with environmental outcomes reports, development corporations, and compulsory purchase. Thank you. So what's happening with EORs? Well, first point to make is slightly surprising they're not called socio-economic environmental outcome reports with ESG on the agenda, but obviously that's something that reflects the legislation on SEA, HRA and EIA superseding. But what's happening is we're going to be moving towards outcome-focused assessments. So SEA, HRA, EIA to be superseded by new EORs for relevant plans and consents. The categories to be determined by the Secretary of State in consultation with relevant public authorities. So the Secretary of State can also interestingly determine the weight to be given to EORs in decision making, another sort of national focus on delivery from the Secretary of State. So there's a tilted balance opportunity for Secretary of State on EORs as well. SOS to make regs to set out specified environmental outcomes against which relevant categories or consents and plans will be assessed. So that's obviously going to be key. What are the outcomes that the processes are going to have to deliver? And then it can repeal or amend existing environmental assessment legislation. So it's expected that that will be superseded to a great extent, if not entirely. So in setting outcomes, the Secretary of State must have regard to the National Environment Plan and obviously under the Environment Act, the subsequent environmental improvement plans. So we're all going to have to be right on top of the detail as to what those plans are, because they'll be informing obviously the outcomes that we're going to have to hit. The legally binding long-term environmental targets and interim targets that those contain will become very key. Now, these outcomes will be subject to public consultation to allow for Aarhus compliance and parliamentary approval. So the whole industry is going to need to look very carefully at the realism of these delivery. It's getting serious in the sense that we need to obviously now focus on the detail of delivery of those targets within the planning system. Guidance to be produced on how plans and consents demonstrate they're supporting the delivery of environmental outcomes. So the guidance will obviously be hugely helpful and important. So when that comes out, the consultation is going to be key. EORs must assess outcomes and the impact of any proposed mitigation or compensation. So we'll still have effectively the impact assessment process, but driving towards outcomes rather than just saying what the impacts are. Consider reasonable alternatives to the consent or plan or any element of it. So that's obviously very important, because if reasonable alternatives need to be considered for each consent or plan or any element of either, that could be quite time consuming, and has been time consuming in the relevant processes that have had to consider that so far. So some degree of reining in of what you have to look at. I was slightly concerned that or any element of it creates an awful lot of analysis that one needs to go through to get these EORs through. More emphasis on monitoring, and this is a big change, outcomes, and the regs may require action to be taken if monitoring reveals a need to increase delivery of an environmental outcome. So you may need to up the level of mitigation, or mitigation, so up the level of mitigation, remedy, up the level of remedy, or compensation in relation to the effects of non-delivery and environmental outcome. So real teeth on monitor and review in terms of having to achieve those outcomes. Cost consequence of that, exit strategies in relation to that, we'll come on to on the next slide. Exemptions for national defence and civil emergency for the SOS-led projects, for example, pandemic response. Next slide, please. So what's the categories of plans and consent? So what's going to be captured? Well, plans that the EORs will be applied to will be specified in regs, but I think it'll be, frankly, all the plans that we're used to. Consents will have category 1 consents, which must produce an EOR, and category 2 consents, which must produce an EOR if certain conditions are met, so not dissimilar to the thresholds that one sees in EIA and SEA at the moment. EIA for category 2 consents, and category 1 consents for EIA purposes, and then the plans, will be specified in the regs. Now, the non-regression clause. So this is a classic Michael Gove, really, isn't it? As he's been always saying that environmental standards won't be degraded post-Brexit. The Secretary of State must be satisfied there is no overall reduction in the level of environmental protection provided by existing environmental law at the time the Act is passed, so we can deviate going forward, but overall reduction leaves some room for manoeuvre. But this is clearly going to cause all sorts of legal issues in relation to challenges and concerns as to whether the EOR regime is actually truly safeguarding what we've got at the time the Act is passed. So I predict lots of challenges in relation to this area. I mean, I'm always reminded it's never a good idea to compare a new girlfriend or boyfriend with an old girlfriend or boyfriend. And my concern is that's what we're going to be looking at, and it's a recipe for concern and challenge. EOR regime must not be inconsistent with implementation of the UK's international obligations relating to the assessment of the environmental impact of the relevant plans and relevant consents. So the international conventions that we've signed up to, as opposed to the European directives that we're no longer bound by. So fees or other charges. So regs may provide for the charging of fees or other charges. So that's going to be important as to whether, as part of environmental outcome assessment, there'll be additional fees and charges that we currently don't have to pay. So watch out for the detail on that. So next slide, please. Pros and cons. So dealing with the pros, well, hopefully we'll simplify impact assessment. Obviously, there's been a drive to that on the SEA and HRA front. So impact assessment on HRAs is also very difficult, but clearly they, what we call European protected sites, highly protected sites, and therefore the impact assessment needs to be thorough. Shift to more emphasis on outcomes, and a lot of the industry, water industry, for example, will be very keen on this for outcome focused environmental objectives. Will make delivery of national environmental improvement plans more likely. Monitoring regime should improve post-completion effectiveness of measures to achieve positive environmental outcomes. That will come at a cost, but will hopefully be more effective. Potentially lower costs of impact assessment and local plan examinations, in particular on SEA, if the process can be simplified. But as you'll see on the con side, concerns about the increased costs of not only achieving outcomes, but also potentially higher fees. And then more flexibility with HRA assessment if more outcome-based. I mean, the number of protected areas where even 10 square metres of loss isn't accepted when you're improving, you know, a square kilometre, because you've got 10 square metres of loss, you're improving a square kilometre of that habitat, but you're still struggling to get past habitat regulation assessment. Maybe there'll be some more flexibility in this new regime. So some issues, challenges in simplifying assessment when you've got to look at those reasonable alternatives that I've already mentioned. Project needing to be assessed and non-regression clause applies. So that non-regression effect on disputes and challenges I mentioned. And then monitoring regime, you know, just think about when you're exiting schemes, who's going to take on that risk transfer of monitor and review? How long will the monitor and review need to carry on for under this new regime? Next slide, please. So moving on to development corporations. So basically we've got a new set of them, locally led urban development corporations, on top of the 4 types of development corporation we've already got. And this is a success story for lobbying, really. Midlands Engine, and we were heavily involved in this, lobbied for this, a new creature of locally led urban development corporations with a wider regeneration remit. So you're not confined just to locally led new towns from a local oversight perspective. Can cover wider non-contiguous areas and different types of projects, including city and town centres, brownfield sites, new employment parks. Can be across multi-authority areas. Hertfordshire Growth Board carefully looking at this across all of those authorities. Local authority consults and proposes what it wants in terms of the boundary and the powers, and Secretary of State decides what it can get. Oversight authority on a local basis can be split functions between relevant local authorities who are participating. So really good news, I think, that we've got this more flexible locally led UDC. More consistent powers then across the development corporation spectrum. So basically it's a rationalisation of powers across all of those types of development corporations. All of them can now become LPAs for local plan making, including minerals and waste plans. That's quite an important point. Overseeing neighbourhood planning and development management. So it used to vary a little bit between different development corporation structures, and that's going to be made more consistent. Brings them into line with how mayoral development corporations currently work, and we've been a lot of experience of that, obviously, in London, and it's been reasonably successful. How those powers are actually bestowed and the process for bestowing them does vary still a little bit, but nothing too much problematic about that. A point that's cropped up in the market in the last week is, are they going to have CPA powers? Well, all development corporations in these guises have got the ability to have CPA powers, although the explanatory notes paper doesn't actually refer to that and deals with plan making powers and DM powers. CPA powers will apply to all of these development corporation structures. And then the borrowing aggregate limit of some development corporations is removed, and the cap on board members of some development corporations is removed for consistency. So generally good stuff. And then for the new town development corporation model, it simplifies the establishment of them, as there were some restrictions which are now moved away from. Next slide. So a few pros and cons. So locally led development corporation allow multiple types of regen projects and cross-authority collaboration, that's good. Standardisation we've talked about, increased borrowing power, good. Simplification of locally led new town DC establishment, good. I think the major observation I've got is, when are you going to have locally led new town development corporations then, if you can have locally led development corporations with a wider remit? It doesn't seem to preclude doing a new town as part of a locally led development corporation, so why not have the wider remit opportunity? We still need to know what the funding position is for locally led new town DCs and locally led DCs. And then establishment time is always an issue for development corporations. How long does it take? And then the mix of powers and the political will to make it happen. And then finally, just moving on to the last topic, compulsory purchase. So some provisions really designed to speed up compulsory purchase and particularly advance the use of the powers. So clarification section 226 for regen purposes to align with Homes England style powers, online publicity of the CPO, the map, as well as the notices. Doesn't yet extend statement of reasons, non-stat documents, but that's the direction of travel. Important point on conditional confirmation of CPOs. So we're now going to be able to have CPOs with conditions which you haven't previously been able to have to sort of reflect the way it works in the DCO regime of allowing CPOs, for example, if funding's not entirely sorted, to have a condition that the CPO will be finally confirmed and activated when funding is eventually known. Operative date of CPO would be delayed until what's called a fulfilment notice is published. Following discharge of all those conditions, objectors are able to make written reps objections to conditions discharge, and regs may provide for reasons to be given for discharge. Similar, as I've said, to the powers under DCOs, but there are pros and cons on the next slide. Representations procedure, no objective right to public inquiry, only informal hearing. So very important point. Confirming authorities can decide either to go down a public inquiry route or a written reps or an informal oral hearing route. So you've got two choices and then a sub-choice on option 2. What that means is an objector can insist on an informal oral hearing, but you aren't guaranteed a public inquiry anymore. Quite a big change. In deciding which option, the confirming authority must have regard to the scale and complexity of what is proposed by the CPO. So one would assume that they would acquiesce to an inquiry where it was large and complex CPO, but interestingly, no express test looking at the impact on an objector. If you've only got one or two objectors who are saying we want an inquiry, it doesn't actually look at the severity of the impact on them as the test to force an inquiry. Next slide. Quickly, yes, time limits for CPO powers implementation procedure to look at vesting dates. 3-year time limit for powers can be extended for implementation of an order, and you can vary vesting dates by agreement with 3 months notice to allow for change in circumstances. For example, if you have got somebody that you wish to vest with and you've issued your vesting notice, but their relocation date's been postponed, then you can agree to postpone the actual possession date to a later date. And then a small amendment to the no scheme principle, just to clarify that transport projects that enable or facilitate development will be part of the scheme, and that's important for no scheme world and scheme world evaluations and cancellation assumptions. Just a quick mention that obviously the Levelling Up bill deals with other compulsory matters such as auctions of vacant high street premises, which is another topic for another day, but elements of compulsion elsewhere in the bill. And then I promised the pros and cons on the next slide. So online document access for statutory documents. So a pro, the con, you need to avoid digital poverty for those without IT, but I think that's been well understood and safeguarded in the bill. Conditional confirmation, trying to get CPOs made earlier for things like funding being not possible to be sure on funding right at the beginning of a CPO process, often chicken and egg problem. But there are some risks associated with allowing for conditions on funding. For example, you might have underprepared CPOs, not really tackling funding as a classic example, or delivery partner appointment not yet as progressed as might otherwise have been. Risk of funding becoming therefore a default condition, risk of objectors revisiting objections at condition discharge stage, shadow of uncertainty of CPO looms for longer, and how are these conditions going to be drafted? Are they going to have some Newbury-style guidance on how to draft CPO conditions? Some people have said, let's go down model conditions, but of course that will reduce flexibility. Didn't work that well for the NSIP regime and it's fallen into disuse, so I'm not convinced by that myself. And then last slide. Removal of right to public inquiry may in theory speed up the process, but I foresee human rights challenges on, is that right to be heard by an inquiry something that ought to be sacrosanct, and is an informal hearing really any quicker when you have to demonstrate a compelling case in the public interest anyway? So not convinced it's going to make much difference. Is it worth a legal challenge risk? And then last, ability to extend time limits, that's a good thing, but there will be a evaluation consequence of potentially having the date for determining, for example, Section 17 certificates on certificates of alternative development at the date of the power being exercised versus the vesting date when you're then looking at the valuation date. So you could have a longer period of time between assumptions in planning terms as to what the land's worth versus the actual value of land at the valuation date later when the vesting actually happens. So you need to watch out for that from a valuation perspective. So that was my slot, and back to Rupert.
Thanks very much indeed, Richard. What we'll do, I think, is we'll just have 5 minutes on specific points arising from that, and then we'll turn to a relatively short wind up of wider questions, particularly thinking about it in terms of particular stakeholder interests and so on. So for those attending, we're about 8 minutes to 11. We'll probably run on if you're able to stay with us for 10 or so minutes after 11 o'clock. I'm very grateful for your continued attendance. As you can see, it's a vast area to cover. I hope we've struck the balance between an overview and detail so far. So just can we start the poll, please, for Richard's topic? Clara, thank you. And while that's coming up, I've got, I think, 3 questions just to pick up that people have raised. And the first is just reflecting on that point. It's this point really maybe that Richard and Tony might be interested in, about the potential for challenge on the environmental front with this switch over to outcomes-based EOR, because plainly, as Richard said, there's the possibility of a big changeover and a downgrading, taking off the gold plating, as it was always put negatively in the past. And also, where's climate change in all of this? It doesn't appear to play a principal role, does it?
No, well, I suppose my comments on that. Firstly, obviously, the non-regression is part of the trade and cooperation agreement. So we've got an international agreement on non-regression already. Query how that's going to be enforced if there was a dispute over that. But that sort of we're bound to non-regression. I think the interesting thing for me and where the challenge will be is setting outcomes for areas that currently aren't outcome based at all. So at the moment, effectively, this is a merger of the EIA regime, which is not outcomes based, purely assessment based, and the habitats regime, which is outcomes based and has assessment as part of it. And if you're going to merge them both together, then you're going to have to find some new outcomes that you're trying to work towards. I think climate change is going to be an interesting one for that. What is the outcome that you're looking for on a particular development in terms of climate change? How does that sit with local and national climate change strategy? Challenge, I think, on these issues almost inevitable, because if you are going to set national outcomes, then those are going to be really determinative of a lot of local effects as well. So why not challenge on your particular interest area, whether it's water quality or whether it's climate change or anything like that? I think those outcomes are going to be subject to a lot of scrutiny and probably some major challenge.
I'm with you, and there's a whole, for those on the governmental side of this, I think we have a few of those still attending, how that's dealt with at the stage of bringing forward these rules, whether they're subject to consultation, to what degree, is it done through primary, secondary, etc., is going to be, a complicated subject. Let's leave it there for now. Thank you, Richard. Just 2 other quick points. Let me respond first of all to John Shaw, who I think rightly detected a bias as ever towards infrastructure and housing and so on in some of these comments that we've been making, as against commercial development. I'm not sure that's the case, actually, John. I think that logistics, data centers, data provision are they straddle, don't they, the boundary between what in the old days we'd call commercial development and what these days might be called a national network or logistics. And so I see them as pretty crucial when you read the planning policy accompaniment to the bill. I think that this is still a role for the MPPF, and I think most of us practicing in those areas feel that whilst we've had a bit of progress in the framework on support for data and logistics, particularly strat logistics and so on, we could do with a bit more in any further work that they do on the framework. So that's how I see that sitting. But can I just come back maybe to Ian on that a point somebody raised about heritage, just connecting to what Richard said about his outcome based and so on. How are the outcomes for the heritage going to work in an EOR, which I think is going to incorporate, isn't it, heritage?
Yeah, I think that's certainly signposted, Rupert. I mean, I think that heritage is already dealt with, isn't it, through environmental impact assessment in any event. But it's not outcomes based, as Richard T and Richard F have explained. It's very much an assessment of impact and harm. So, perhaps we're moving towards a more positive system where we are required to think about how those heritage assets can be enhanced, their setting can be enhanced, the contribution they make can be enhanced. So, I think a positive move. And again, as I said earlier, I think the opportunity for the National Development Management Plan documents to deal with heritage at a national level is to be welcomed. So I'm sort of feeling pretty positive about that as a possibility at the moment, Rupert.
I'm with you. I think it's a real opportunity to deal with a couple of things. One is the feelings that many have, not everyone, but many people have about how unworkable, how difficult to work the less than substantial harm aspects of the framework are in practice. But also, as I'm finding in almost every appeal or call-in that I'm doing at the moment, the mismatch between significance of impacts in the environmental statement approach to heritage and what's said in the framework. Are they the same? What does adverse, what does moderate mean in those two contexts? So it is an opportunity, I think, that I'd certainly welcome to sort that out. Let's just check on our poll. So this is a broad question, obviously, because it covers all of those areas that are including plan making oversight in SEA. Again, it's interesting, isn't it? About 2/3 to 1/3 in terms of people's views, generally positive, perhaps because of the harmonisation and the focus on outcomes rather than process. Richard, do you want to offer any final thoughts on yours before we move to the winding up session?
Well, what is an environmental outcome? I mentioned at the beginning the socio-economic side. Is having places that are beautiful an environmental outcome? Is a home for people an environmental outcome? So the socio bit for me is quite important because obviously socio-economic appraisal is part of EIA, SEA. So how far are these environmental outcomes going to get involved in the social element is very important. And Richard T's point about some outcomes are hard to identify and specify and will be argued over is absolutely the devil in the detail, isn't it? And that's going to be what we'll be all poring over on a national basis and B, a local basis on assessment. Yeah,
agreed. Well, thank you very much, Richard. We'll move then to our concluding session, if you like, for 10 minutes or so. Thanks for bearing with us. We've got a poll for this, I think, as well, haven't we, that we can run throughout this short final session. So, Clara, when you've got a moment to put up that poll, then do so. I thought it might be helpful to approach this final session by stakeholders or by sectors, if you like, because many of you have obviously particular interest as well as general interest in how this is all going to work. And so I thought of a general question about what's the best outcome for a particular stakeholder and what are the risks might be a good way to do it. And so I'm going to pick on the panel to deal with things stakeholder by stakeholder, if you like, or area by area. There's the slightly more complicated question that I'm asking on the poll. So I wonder, in terms of investment, just thinking back to the themes of the government recovery, simplifying the system, making it better for investment. Wonder if I can come to Ian on that. What's the main plus, if you like, or main minus in what we're seeing?
Yeah, thanks, Rupert. Well, there's a whole bunch of them, aren't there? I mean, it's difficult to avoid kind of hackneyed aphorisms as you kind of wind up on these discussions, really. Richard Ford has already hit the devil in the detail swear box, so I won't repeat that one. But I think the general approach is keep calm and carry on. The development community professionals, on this call and listening in today, have shown really incredible adaptability to planning reform over the years. And developers, investors are kind of used to the planning system being kicked around. So I think the medium and long-term prognosis is that in overall terms, it won't make that much difference to investor appetite for commercial and residential real estate opportunities in this country. I mean, it goes without saying that the best way to protect and hedge yourself against the impact of these changes is to take advice sooner rather than later to make sure that you understand what's coming. The real work will be in understanding the regulations. The bill sets a framework. It's probably worth reminding ourselves, of course, the bill's got to go through many stages of scrutiny in Parliament. So what we see today won't be the final form of what emerges, but let's assume that something like it is on the statute books next year. It's the regulations, the policy, the new National Development Management Policy Framework, changes to the NPPF. That's where the real work needs to be done, and that's the material that will impact upon investor confidence. So as I said earlier on, the speed at which that material is produced, consulted upon and closed is critical, because what investors don't like is uncertainty. So I think just finally, I think it is very much a case of no change at the moment, of course, until the bill becomes an act. Nothing changes. The local plan system changes as it is. 106 agreements and SIL are as they are. So we just need to keep our nerve and keep working through the detail.
Thank you, Ian. Let's look at it from a different angle. Can I come to Richard T? From, broadly speaking, more public sector area, local planning authorities, counties, joint authorities, what's the takeaway as far as you can see it?
Well, there are two parts, obviously, to the local authorities. There's the political side and the officer side. I think in terms of the politics, clearly local authority members are going to have to decide whether they're serious about getting plans in place and up to date. And there are carrots and sticks in these provisions. There's also a threat of these new local plan commissioners, which obviously is the basis of a Secretary of State intervention. So somebody, more scope for intervention, perhaps. So sort of, if they're going to take action, who are they going to take that action with? Is there a case for joint working, for spatial planning at a regional level, and so on? So those are the debates that I think politicians need to be having now, because they may become under pressure quite quickly after enactment to say what they're doing. For officers, they're obviously going to have to bear the brunt of the transition of trying to re-gear existing policies around this new framework and get stuff prepared. So they'll be doing the hard work. But I think, from my perspective, it's really the political question, whether local authorities are going to take this as a cue to change their approach to plan making, or whether they're going to sort of see it as business as usual. In the framework that we've got, I think either would be possible. And so it's going to require some political thought.
Yes, I mean, and it will be different, presumably, in different places, won't it? How that pans out. Yes, I'm just looking at the poll result, and then we can take that off the screen. Lara, again, a degree of scepticism, I think. Number two, delay to plans and no increase in permissions being 2/3 of the votes cast, because obviously we're seeing already, aren't we, in anticipation of these changes, a slowdown in a number of plans. In fact, the wheels coming off a number of plans, and that's a possible outcome, isn't it, for at least the next 6 to 9 months?
That's the risk, isn't it? This
Yeah.
bill it probably avoids some of the controversy, certainly compared to the bill that was being touted in the white paper.
Yeah.
But I don't think it's going to have a completely smooth passage. And planning bills historically have been a sort of source of people putting their pet projects forward. So there may be quite a lot of delay and amendment as it goes through. And then obviously there's whether, how it fits into general political timetabling in Parliament.
Yeah.
And whilst that's all up in the air, the incentive may be to do nothing, or to slow down, or to withdraw from existing processes.
Yeah, I'm with you. And also, just on your political point, before we turn to Caroline, one of the things that struck me reading it all through was the references in the planning paper. Did you see those to the Renaissance and so on? Which one can smile about. But of course, the Renaissance was based on city-states, as I recall. And here, it just seems to me that there's a lurking political elephant, isn't there, in the room about how much power you give to, e.g. Andy Burnham, where those city-states tend to be Labour-controlled rather than Conservative controlled.
And we're already seeing that political battle, aren't we? I mean, the slight watering down of London powers, but more importantly, the deliberate attempt to align them both in language and in terms of the substantive content of the provisions with other spatial development strategies. You're not special. Mr. Khan. You're the same as any other region, which may be part of levelling up, but is going to cause a political issue.
Yeah. It's part of levelling up and also part of something else that we've been seeing, over the past few years. I'm with you. Thank you. Caroline, can we come to you on seeing these changes from housing delivery, house builders, promoters, etc.'s point of view? What are the main takeaways, do you think?
I think the first one, which we actually haven't discussed today because there's just been so much content, is around the proposal to amend planning permissions to provide greater flexibility under Section 73.
Yeah.
And I think that's a key one for house builders in particular. We deal with them a lot, and in terms of Section 73, that is, with housing schemes, and it is a bit clunky. So the proposal is or the bill makes provisions for making non-substantial changes to permissions. And there's a question around what that actually means, and I think there will be, to a certain degree, as happens now, the sort of local authorities across the board taking different views on that. But one thing that is good in there is that it includes flexibility around description of development and the conditions. And that's set out in the explanatory notes in the bill to the bill. So I think that will be welcomed and hopefully will be seen through to the enactment stage, which I think will be helpful. And the other area is really, I guess, just monitoring and engaging in the various consultations that are coming out that affect house builders and promoters. So the environmental outcomes report, and all the questions and issues around that Richard raised, infrastructure levy, and not only how it affects how it'll affect developers in terms of their the payments that they make, but also around infrastructure and their contributions to infrastructure and how that's assessed. Planning fees, consultation on that, big jump in over a third. For major applications, and then probably the vision that the NPPF is going to put forward, and hopefully included within that the approach to housing supply, because we don't have much more.
One can only hope. One can only hope.
Yes.
Yeah. But you're right. I mean, I think if you look across the country, including London, how many plans that have actually come into fruition in the last, say, 10 years are, have as their cornerstone one or two very large sites. I mean, particularly outside London, obviously. Some of them, like in Essex, have founded on infrastructure aspects to do with those big sites and new communities. even if there's just one, usually extends beyond the plan period and so on. And those issues, I thought, well, all of the issues that have been discussed, but particularly those around infrastructure, I think how you view what it is and when you're going to have to pay for various things just seems to me to be, one of the front and center things for house builders, as you rightly say. Thank you very much. Richard Ford, could I, or just on the infrastructure point, I'm thinking here more about the functioning of the IL. What do you think for those who are directly involved in the provision of infrastructure? So those involved in nuclear, for instance, which in the light of current events we gather might be more important. Do we get any takeaways on that?
Well, I think on the nuclear sector, this isn't hugely significant because that's obviously Planning Act process. But I think in infrastructure terms, I think the levy is, most people would breathe a bit of a sigh of relief that it could have been worse, but I think they're comparing it against the original CIL. When you compare it with CIL and 106 as it is now, how much better will it be? And yet it's yet more change. 6 a dozen one, half dozen the other, I expect in macro terms. But the real game changer is affordable housing via the levy, as we discussed earlier, I think, on infrastructure. And that's going to be, really important to get right. My sense of the overall bill is that it's kind of does something for everyone. I mean, I wanted to give a shout out to DLUC, actually. They put a lot of thought into this bill. It's a lot better than the white paper. It's very interesting in its content, but there's something for central control. Absolutely power grabs for central control. There's something in it for Devo authorities, particularly county council enhancements and combined county councils. And there's something in it for localism, although street votes will have to wait and see. I mean, I'm quite interested in the TAMA 38 experience in Israel that the Policy Exchange paper took forward and simplified and probably, made less stringent. But that's going to be very interesting. And it's what I call classic Gove political bill. It's something for everyone, but how does it all fit together? But what I do think is credit to the planners at DLUC for, listening and taking on board a lot of the lobby requests from people on where there are problems in the system and trying to do something about it. And I do think that's positive. I think in the short term, like any change, it causes issues. Is it the right time in the economic cycle to be doing this when you've got macroeconomic issues that are probably more problematic for investors and developers than anything else? More change at a time of economic uncertainty creates issues. However, in the medium to longer term, I see benefit from this bill to the industry and indeed, hopefully, in the environmental and socioeconomic outcomes side as well. So generally speaking, I think it's interesting and a positive development, albeit lots of detail and analysis to come.
And I think I look at the screen to see my fellow panelists' heads. I think that's a general view that we share, isn't it? That there's a lot that's positive about it, and I'd certainly echo what you say about DLUC and the work that they've done compared to where we were, say, 18 months ago. For me, and if I take commercial just as an illustration of this, commercial logistics data and so on, we've got our PD aspect of government policy, which is pretty quiet in this set of work that's coming forward, still presumably going to be going on, affecting that. But the key work is going to be on those areas in the framework, I think, and the management policies that are going to be embedded in the plan. And if those are clear and effective, then I think that could have a very marked beneficial effect on how the system beds in. So that's obviously not for today, but for a future point. I mean, one friend of ours, Mark Buxton, asks, do we think that actually in the end this is all going to get dropped? I don't know what people think. I mean, Richard F shakes his head. I mean, some of it will work, I guess, and some of it won't. But what you've picked out, I think, between you seems to me to be those things that are more likely rather than less likely to go forward.
I think that, assuming that the government survives long enough, and I expect it will with its majority, talking about snap elections and things, I'm not entirely convinced myself. But assuming it carries on for the full term, then I think it will go through. How it gets amended throughout, obviously we'll wait and see, but the general thrust of it, I think, will get through and will happen. There will be banana skins, as always, and there are some highly political elements to this bill. They've shoved a lot in. I mean, I was thinking about it last night. The kitchen sink is in here. Obviously, what's not in here is always worth thinking about too. I mean, particularly the housing numbers, and that's the major omission. But that's something that, you know, will come forward later.
And I guess we'll be interested to see Labour and indeed Lib Dem responses to this going forward, because there's quite an area of it I think we all recognise that is, generally speaking, if you like, cross-party in some of its effects. And I wonder, obviously Labour have already said, haven't they, that they wouldn't get rid of the framework, the NPPF, if they were to come to power. And you know, it's pretty difficult for generally, though it may be rebadged, levelling up to be inimical to the Labour message at the next election. The trouble they've got, I think, is being, you know, accused of being copycats rather than, and they will say that, you know, that's what the Tories have done. But I mean, I think it's one question I thought I'd just canvass that's been raised with you is in terms of date and progress of the bill to finish on. We'll see the NPPF and so on in due course later in the year next year. What's our feeling about how long the bill process might take? Does anyone have a view on that?
Well, I mean, when the chief planner and Simon were doing their broadcast, they were saying early next year was the target. I expect it might take a little bit longer than that because of the controversies over some of the topics. So I think towards the back end of 23 would be my guess, maybe early 24 if we're unlucky, but hopefully by the end of next year.
Yeah, I agree with that, Rupert. I think that is it 38 bills heralded in the Queen's speech. I mean, there's obviously a lot of people today who think that the levelling up and regeneration bill is the most important of those, but there will be a lot of folk who think some of the other bills are more important. So it's a packed parliamentary programme. I'm finding it difficult to see that timetable of early next year is going to be met, which is why I think we go back to what we said earlier in terms of investor confidence, etc. We have to assume that the current system remains in place for the foreseeable and plan and make decisions accordingly.
Yes, agreed. Do you agree with that, Caroline? I
do, yeah. Sorry, I've got to shoot off.
No, not at all. No, not at all.
Apologies.
Thanks all. Thank you, Caroline. I mean, Richard, in terms of what might happen in 2023 to this, obviously we'll have the framework coming forward, and quite a lot of political decisions, I guess, will, you know, have been conditional on what might come forward in the rest of the wood, if you like, as affecting the content of the bill.
Yeah, I mean, I suppose this bill has an easier passage until national development management policies and framework get published, and then people start to argue about the substance. So I suppose it might depend a bit on how that is choreographed over the coming months to get the bill through quite quickly, and then to publish everything else that's going to cause the real arguments, EORs and so on. That it's a sort of strategic point, really. But I think this is going to be on the statute book in some form. It seems to me that, you know, we've been trailing a planning bill for a long time. There's you know, no doubt this Secretary of State will want to have a major planning bill. So I think it will be seen through, and it may actually be relatively quick. But I think relatively quick still means you know, next year probably.
Yeah, no, I agree with that. I mean, the centrality of you know, the reappearance of the expression golden thread in the policy document relating to levelling up across the whole of the government agenda, you know, using it as a test or, you know, lens through which to see all of these policy changes and various bills is quite telling. I mean, the idea of not bringing forward, you know, most of these changes in the very bill from the very department, which is kind of the master department, if you like, on levelling up, seems to me to be unlikely. So there's a political imperative, I think, that will drive the enactment, and it depends. I think, you know, political decisions will drive exactly when it happens. You're right. So in a sense, that's a positive note to end on, because we're not wasting our time. As Ian says, and Richard says quite rightly, it's a keep calm and carry on for the moment, participate very heavily in the forthcoming consultations and talking in general terms about this, with the expectation that quite a number of these changes in one form or another will come in, both legally and in policy terms in due course. So I think at that point, I'm very grateful to everyone, including especially the 460 odd people who are still attending and watching this webinar. Full marks for stamina. You'll appreciate, obviously, that I think this is, we can see what's poking above the water. We hopefully have given you a sense of how big the iceberg is that's below the water. And I hope that's been as helpful as it possibly could have been at this stage of things. But just to echo what Richard, I think, said towards the beginning, inevitably, there are 15 doors of further work now open through which most of us are going to have to go. Some of us will be on the other side, some of you will be coming through the doors. So on that note, can I thank very much indeed the speakers. Caroline's left us, but Richard Turney, Richard Ford, Ian Gilby, and thank very much the organisers at Landmark, Pinsent and BNP, and bid you good day in the hope that you've found it useful. Thank you very much indeed.
Thank you.